Hi everyone, my name is Vlad Genshu and I am a personal injury litigation and trial attorney here in Los Angeles, California. I'm going to talk to you today about the words you choose to use, your decision, your choice, during a civil jury trial here in California State Superior Court. The words you choose to use will convey a message about the case, a message about how you yourself speak and how you see yourself, and also how you see the jurors. And they're going to be critical in terms of how the jury ultimately reaches their verdict. And what I want to talk to you today in this video is basically the idea and the concept that a lot of lawyers talk like law professors, and they make a critical mistake when they do so. Just a little bit to give you like a 30-second snapshot. My original background is in politics. I cut my teeth in politics working on campaigns from the age of 15. Most of the politicians and elected officials that I worked for were lawyers. A lot of them had high-end law degrees, Harvard, et cetera. I can assure you that none of them used big words in front of their audience, which were the voters. Whether it was a voter of a state legislative district in Pennsylvania or somebody running for city attorney here in Los Angeles, you don't use big words because it doesn't make you look smart. It makes you look like you're condescending. So I'm going to remind you, it's kind of like on a campaign website, nobody needs to know that you went to Harvard. That's not on there if you went to Harvard. The donors already know, okay? So let's just go and talk to you about the word choice that you use in front of jurors. This is critical. They say, meaning trial lawyers who've tried cases, jury consultants, that the average juror's education is about an 11th grade education. Whether that's true or not, 10th, 11th grade, some high school, most likely these are working Americans who didn't have the blessing, the opportunity, the privilege to go to a 4-year academic institution, to go to get a master's or a law degree or an MD or a DO or a DDS or anything like that, be a veterinarian, a PhD, none of that stuff, right? Obviously, there's situations where that's not the case. You might have a trial in Beverly Hills, a trial here, whatever, criminal trial in Newport Beach. Hey, I get it. Those guys, I had a trial in San Diego. During jury selection, I even told the jurors, wow, this is like, there's a saying in Romanian, unu și unu, 1 and 1. It's like the cream of the crop, right? One owned a biotech company or a portion of it. Another one had a PhD. That's rare. Most people, they're going to be working folks. So don't use words. I want to talk to you about common words that I've seen. I'm going to give you examples. Don't use the word prior. Don't use the word prior. My joke is, unless Richard Pryor is going to walk into your case, your trial, and he's going to sit and he's going to be one of your witnesses, don't ever use the word prior. Obviously, it means before. A lot of jurors might not know what that means. And if you have a Mr. Pryor in your case, still use the word before, okay? That's what you want to use. This concept, too, don't use the word depict. Why do we use the word depict? It means to show. But why? Why use it? Why? Because you went to law school? I'm going to be brutally honest with you, to use a term that Nick Rowley uses. I saw Arash Hamanpour yesterday do a cross-examination. It was beautiful. It was excellent. Used normal words, right? Such command of the facts, of the entire back and forth of cross-examination. Then I saw defense counsel come up there. I don't think he did anything necessarily wrong, but he used words like prior and depict, and every question was very stilted. I think that there's a natural human tendency when you get something that's stilted, or even as he said, and I heard him talk to say it outside of the hallway. He said even when it's a little bit too cut and dry, that we want to use big words so we can appear smart. Don't do it. The jurors are not going to like it. Let me tell you another reason why not to do it. Many times as plaintiffs' lawyers, we're blessed to have clients who are bilingual, and maybe their dominant language is not the English language. I know. My family, we came from Romania. My grandmother never really learned the English language. She came here in 1991. I think she was about 1991. She was about 58 years old. I never learned conversational English, never learned English to the point that she could, go to court. Many of my clients are the same way, right? we as lawyers, we understand that jurors prefer people who make an effort to speak English. So what do we do as attorneys, right? We try to make sure, hey, can they actually testify in English, right? Hopefully, if they testify in English at trial, they did so at the deposition as well. That's a totally different topic. But here's the thing. If you're going to use big words in front of your client might not know those words. I had a case in Orange County where literally it was the word prior. And on direct examination, the client just flew through the testimony. She did great on the questioning that we asked her, that my co-counsel asked her. And then cross-examination started, and defense counsel went up there and then started using the word prior. She didn't know the word prior, so it looked like she froze up. The jurors thought she wasn't being straight. She wasn't being honest. How could she answer our questions and not opposing counsel? I think we did a video on that earlier. The point is, you got to know how much mastery of language your client has and the jury has, okay? Otherwise, you're going to look like a buffoon. You're going to look like a dunce hat, somebody who's a law professor. And we love our law professors. God bless them. They have no business trying cases, okay? Unless they're an adjunct. They have no business trying cases. So what I want to say here is use simple words. Use the kind of words you would use with your 10th grader or your 10-year-old, okay? And try to give that elevator speech, that elevator speech, okay? If you can't put it together with normal words, why should the jury listen to your complicated words, all right? To me, even at the risk of sounding a little bit too folksy, you're better off talking like a man of the people or a woman of the people, if you will. So when I look at that, when I look at the questions out there that counsel asks, just use plain words, okay? And here's the test that I would give you. We all took either the ACT or the SAT. I took the SAT. If you took the SAT in the verbal section and you think that some of the words that you were using, okay, would be like in the last part of the verbal questions, like the hardest ones, to see if you get the 750 or the 800 on the verbal, don't use those words. Just stay away. If you're going through medical testimony, have the doctor explain what that means. Okay. Well, what were her subjective complaints? What were her objective complaints? Have the doctor explain, what does that mean? Well, what are her complaints? Just what does that mean? What complaints? Who talks like that? Nobody talks like that. Just tell them, look, doc. Don't say doc. That might be a little bit too informal. Doctor, what does the term complaints mean from a medical standpoint? Okay, and what does that mean? Her pain, okay, and subjective complaints. What does that mean? Just break it down. Don't overdo it, but break it down. Use words that the jury will understand, and the jury will respect you, that you're not trying to hide something or sound too much like a lawyer. Being a trial lawyer, trying civil cases, whether it's a business case or a car accident case, trip and fall case, slip and fall case, or a criminal case, that's where you're closest to the community, because they're right there making that decision. They have that legal authority, that just power to make a decision for your client. Talk to them like you would see Bill Clinton or Barack Obama or some of the best public speakers talk. Don't talk down to them. Talk to them. Empower them. That's what you want to do. You're not going to get any extra credit points for using a word like when this complaint was filed. Just say, when this lawsuit was filed. All right, my client was sued. Or you know what? My client's the one doing the suing. She's a suer, the plaintiff. You can't hide from it. The defense attorney is going to bring it up anyway. Just keep it real with the jury. If your case is strong, using words that everybody can understand will make it stronger. If you have a trash case, using Harvard College get you into based upon your verbal SAT score won't do a thing for your case. Keep that in mind when you're going to your next jury trial. And if you're blessed to have kids, if they're 10, maybe 11, try to give them, again, the elevator pitch. Hey, here's my spiel. What do you understand? Use the words they would understand. And if you got a precocious 11-year-old or 12-year-old, then try to use simple words around them too. Best luck at your next jury trial.